In the reading room of the Library of Virginia, in a bound register of births recorded in the year 1924, there is a page where a single word has been crossed out. The word was Indian. Above it, written in a smaller, tighter hand, is a replacement: colored. No signature explains the change. No court ordered it. No parent consented to it. And yet that one stroke of ink, made at a desk in Richmond by a man most Virginians never voted for and could not have named, would follow the child on that line for the rest of her life. It decided which schoolhouse door would open for her. It decided which half of the train she could sit in. It decided whom she was legally permitted to marry under penalty of prison. And decades later, when her grandchildren tried to prove to the federal government that their tribe had existed at all, that same stroke of ink was waiting for them in the file, insisting that it never had. This is the story of how race in America became a matter of paperwork, not of ancestry, not of community, not even of appearance, but of what a registrar in Richmond decided to type onto a certificate, and of the 46,000 square miles of one state where a single bureaucrat spent 34 years editing the identity of the living and the dead. Along the way, you are going to meet a 19-year-old bride who dragged this system into a courtroom in 1924 and beat it. You are going to read an exception, buried in the law itself, written specifically to protect the bloodlines of Virginia's oldest and wealthiest families. And you are going to hear, in the man's own words, preserved in his own correspondence, exactly which European government he believed his filing system had outperformed. He named it, in writing, in 1943. So keep one question in front of you for the next half hour. Not the question of what race is, the question of who holds the pen. Here is precisely what this episode will put on the table. First, the single sentence at the heart of Virginia's 1924 Racial Integrity Act, roughly 24 words that attempted to define the word white in law, and why those words made almost everyone in the state legally suspect. Second, the so-called Pocahontas exception, the carve-out written into that same act so that Virginia's first families who traced their fortunes to a marriage in 1614 would not be erased by their own law. Third, the circular letter of January 1943, in which the state registrar mailed lists of specific family surnames, county by county, to every clerk, nurse, and school superintendent in Virginia, flagging living families as suspects by name. Fourth, the courtroom in Rockbridge County where Arthur Sorrells, 19 years old, forced a judge to ask whether racial purity could be proven at all, and won. And fifth, the long arithmetic of erasure, the way paper destroyed in the 1920s delayed the federal recognition of 6 Virginia tribes until January of 2018. Every one of those 5 will be paid in full before this episode ends. A note on method, because it matters here more than usual. Nothing in this episode rests on rumor. The registrar in question wrote constantly, and his letters, circulars, and forms survive in the Library of Virginia's collections and in court records, quoted by the historians who have worked through them, scholars like J.G. Douglas Smith, whose book Managing White Supremacy traces the machinery of Virginia's racial state, and Erica Coleman, whose study That the Blood Stay Pure follows what that machinery did to Black and Indigenous Virginians, and the journalist Warren Fisk, whose 2004 investigation for the Virginian pilot put the registrar's own files back in front of the public. When this episode quotes him, it is quoting paper he signed. The man behind the pen was named Walter Ashby Plecker. He was born in 1861 in Augusta County, Virginia, in the first year of the Civil War, took his medical degree from the University of Maryland in 1885, and spent his early career as a country doctor before settling into public health work around Hampton, in Elizabeth City County, just after the turn of the century. And here is the detail that makes the story uncomfortable rather than simple. By the accounts of public health historians, Plecker was, early in his career, a genuinely effective health officer. He pushed for trained midwives at a time when most Virginia births happened at home, far from any physician. He wrote out simplified instruction cards for midwives who could barely read, insisted on silver nitrate drops to prevent newborn blindness, campaigned for clean birthing practices and careful record-keeping, and infant deaths in his jurisdiction fell. He believed in the file. He believed that a life unrecorded was a life the state could not protect, a child the state could not vaccinate, a death the state could not investigate. That belief is what made him useful, and it is also what made him dangerous, because in 1912 Virginia created something it had not reliably had before, a statewide Bureau of Vital Statistics, and it handed the entire apparatus to him as its first registrar. Consider what that timing means. Virginia's statewide birth registration had actually lapsed in 1896 and stayed dead for 16 years, which means an entire generation of Virginians had no state birth record at all. The ledger of who was who in Virginia was, in a very real sense, blank, and one man had just been given the only pen. He would hold it until 1946. For his first decade, Plecker mostly built the machine. Forms flowed from midwives and physicians to local registrars, thousands of them scattered across the counties, and from local registrars to Richmond, where they were indexed, filed, and made permanent, and Plecker enforced compliance with the zeal of a man who genuinely believed the file was civilization. Then, in 1922, the machine met an ideology. A celebrated Richmond concert pianist named John Powell, a man who toured internationally and filled concert halls, founded, together with a writer named Ernest Sevier Cox, an organization called the Anglo-Saxon Clubs of America, dedicated to what they called the preservation of white racial purity. Within about a year, the Richmond Post alone claimed some 400 members, with chapters spreading across the state and into the universities. Cox had just published a book called White America, and the whole movement drank from the same well as Madison Grant's The Passing of the Great Race, the pseudo-scientific bestseller of 1916 that dressed racial hierarchy in the costume of biology. Powell had the audience. Cox had the doctrine. Plecker had something neither of them had. Plecker had the files. And in March of 1924, their alliance produced a law. On March the 20th, the Virginia General Assembly passed the Racial Integrity Act, and it is worth pausing on what else that same season produced, because in the very same session the Assembly also passed a compulsory sterilization law, the one the United States Supreme Court would uphold 3 years later in Buck versus Bell, the case of Carrie Buck, a young woman from Charlottesville sterilized against her will, after a proceeding historians have since shown was essentially staged. Justice Oliver Wendell Holmes wrote the opinion for an 8-to-1 majority and closed it with the sentence, "3 generations of imbeciles are enough." Under the shelter of that ruling, Virginia would go on to sterilize more than 8,000 of its own citizens. And in Washington that same spring, Congress passed the Johnson-Reed Immigration Act, slamming the national door on the basis of the very same racial arithmetic. 1924 was not one bad law. It was a system arriving in pieces, federal and state at once. And the piece that touched the most lives was not the loud one. It was the quiet one, the one about paperwork. So how did the paperwork actually work? In plain terms like this, the Act required that every birth, marriage, and death in Virginia be registered with a racial classification, and it made the willful false registration of race a felony, punishable by a year in the penitentiary. It reached backward, too, offering voluntary registration certificates for everyone born before 1912 in that 16-year gap when the state had kept no records, which meant millions of adults were invited to file their own race with Richmond under the same felony penalty if Richmond later disagreed. Every applicant for a marriage license had to state their race to the clerk, and the clerk, who knowingly issued a license in violation of the Act, faced punishment himself, which turned every county courthouse in Virginia into a checkpoint and every clerk into a deputized enforcer with his own liability to worry about. Then the Act defined its terms, and the definition is the sentence this episode promised you. A white person, the law said, was a person, quote, who has no trace whatsoever of any blood other than Caucasian, no trace whatsoever. Read that sentence the way a clerk had to read it. It is not a standard a human being can meet with evidence. Nobody in 1924 could document every ancestor back through 3 centuries of colonial Virginia. a colony where English, African, and indigenous people had been living, working, and having children alongside one another since the 1600s, which meant the definition did not really define who was white. It defined who got to decide, because when proof is impossible, classification becomes discretion, and discretion belonged to the man who kept the files. And when even that standard proved leaky, the Assembly tightened it. In 1930, Virginia amended its code so that any ascertainable trace of African ancestry made a person colored in law, the purest statutory expression of the one-drop rule ever written in America, and a rule that conveniently collapsed the category Indian toward extinction, exactly as the registrar wanted. Except the drafters had already hit a problem of their own making back in 1924, and this is the second promised item. Many of Virginia's proudest and wealthiest dynasties, the families whose names were on the counties, the colleges, and the bank boards, the Bollings, the Randolphs, and their kin, openly and proudly traced their lineage to the 1614 marriage of Pocahontas and the tobacco planter John Rolfe through the couple's son Thomas. Descent from Pocahontas was not a secret in Richmond society. It was a credential, printed in genealogies and toasted at dinners. Under a strict reading of no trace whatsoever, the first families of Virginia were not white. Their own law erased them. So the Assembly wrote them a door, and the width of that door was haggled over like any other piece of legislation, with early drafting talk of a 1/64th allowance before the final act settled on something far more generous. The law as passed declared that a person with 1/16th or less of American Indian ancestry and no other non-Caucasian blood would still be counted as white. Historians call it the Pocahontas exception and sit with what it admits. The one-drop standard was absolute, right up until it inconvenienced money and pedigree, at which point it bent. Purity, it turns out, was negotiable. What was never negotiable was who held the ledger. And Plecker used the ledger with a thoroughness that still startles the researchers who read his files. He compiled lists of surnames he considered suspect, building them from the free persons of color schedules of 19th century censuses, from 1830s tax rolls, from old county birth registers, and cross-referenced all of it against every new certificate that came through the door. He had academic cover too, because in 1926 the Eugenics Record Office at Cold Spring Harbor published a study by Arthur Estabrook and Evan McDougall called Mongrel Virginians, a supposedly scientific field survey of the mixed ancestry families of Amherst County, the very Monacan community you are about to meet, thinly disguised under the pseudonym The Wind Tribe, and Plecker cited that kind of work as proof that his lists were biology rather than suspicion. Meanwhile, an actual anthropologist, Frank Speck of the University of Pennsylvania, was visiting Virginia's tribal communities throughout those same years, photographing them, documenting their languages, kinship, and continuity, and publishing the evidence, and Plecker treated him as an enemy of the state's records. When a certificate arrived in Richmond marked Indian or white and the surname appeared on his lists, Plecker intervened. He mailed his pamphlet on eugenics and the new law to mothers along with their children's birth certificates. He threatened midwives, the very workforce he had once championed, warning them that recording a suspect family as white or Indian could cost them their registration and land them in the penitentiary. And here is the hidden detail that most retellings skip. Plecker did not have clear legal authority to destroy or rewrite a certificate that had already been filed. So he did something arguably worse because it was quieter. He attached notes. He clipped warnings and genealogical memos onto the original records so that anyone who ever pulled the file, a clerk issuing a marriage license, a school board, a draft board, would find the state registrar's opinion stapled to the person's identity. The certificate said one thing, the file said another, and in Virginia, the file won. That struck through word in the birth register this episode opened with was not an isolated correction. It was one visible edit in a correction system that ran for over 3 decades, and to see what that system did when it reached into an actual household, you have to watch it arrive in 3 different doorways. The first doorway was in Lynchburg in 1924, months after the act passed. A woman there, recorded in the correspondence as Mrs. Onethays, Robert Cheatham, had just given birth, and the birth had been registered as white. Plecker reviewed the paperwork in Richmond, decided the family's ancestry was suspect, and wrote directly to the new mother. The letter survives, and it is quoted in histories of the act. He warned her, in his words, that this was a mulatto child and that she could not pass it off as white, and he reminded her that a false registration of race was, quote, a penitentiary offense. He sent a parallel warning to the midwife who had attended the birth, putting her livelihood on notice for the crime of writing down what the mother told her. Read that sequence again slowly. A mother registers her baby. A bureaucrat she has never met, in a city she may never have visited, reads the form, overrules her, reclassifies her days-old child by mail, threatens her with prison, and threatens the woman who delivered the baby for good measure. Not a judge, not a jury, a registrar with a letterhead. The child's schooling, seating, marriage rights and legal standing had just been altered by postage. The second doorway was on Bear Mountain in Amherst County, among the Monacan people, a nation whose presence in the Virginia Piedmont long predates the colony itself. Under Plecker's regime, Monacan families found the word Indian systematically stripped from their paperwork and replaced with colored, because Plecker insisted, in circular after circular, that no true Indians remained in Virginia at all, only people attempting, in his view, to escape their classification. The consequences were concrete and generational. Monacan children were barred from the white public schools, and the county offered them no Indian schools because, on paper, no Indians existed. For decades, the main education available to Monacan children was the small Episcopal mission school at Bear Mountain, run out of St. Cana, Paul's mission, and by tribal and historical accounts, for much of that era it could carry students only into the early grades, at best into the 7th. A Monacan family that wanted a child to see the inside of a high school had essentially one option, and it was to leave Virginia, sending teenagers hundreds of miles away to boarding schools in other states if they could afford it at all, and most could not. Think about what that means as an economic fact on a channel about money and power. Education capped at grade school means labor capped at farm work and day wages. It means contracts you cannot read closely, deeds you cannot contest, credit you cannot get. An entire community's earning capacity, land dealings, and legal standing were capped for 2 generations, not by any event in their lives, but by a category in a filing cabinet 100 miles away. The third doorway opened in wartime. When the Second World War came and the draft boards began pulling files, young men from Virginia's tribes discovered what Plecker's annotations were worth to the federal government. The military of that era was segregated, and Virginia's records now declared these men colored, so they were ordered into units accordingly. Plecker personally corresponded with draft officials to make sure his classifications held. Some men complied under protest, serving a country that would not record their nation's name. Some found workarounds, getting inducted through other states or securing letters from anthropologists like Speck vouching for their identity, and some refused outright. By tribal and court accounts, at least 3 Rappahannock men refused induction under the classification colored, insisting they were Indian as their fathers and grandfathers had been, and for that refusal they were convicted and sent to federal prison. Hold those 3 doorways side by side. A newborn in Lynchburg, a schoolhouse on Bear Mountain, a courtroom sending draftees to prison over a checkbox, same pen, same desk. And in every case, notice what never happened. Nobody ever examined the people themselves. The system did not need them. It only needed their paper. But paper systems have a weakness. And this is where the story turns, because the same decades that show the machine at full power also show, in 5 distinct moments, exactly how it was fought and finally taken apart. Moment 1 arrived astonishingly early in November of 1924. The act barely 8 months old, and it is the payoff of this episode's 4th promise. In Rockbridge County, a 19-year-old woman named Afa Sorrells applied for a license to marry a white man, and the clerk, guided by Richmond's suspicion of her surname, refused her. She did not accept it. She took the Commonwealth of Virginia to court, and the case landed before Judge Henry Holt. Holt looked at the statute's demand, no trace whatsoever, and asked the question the drafters had hoped no judge would ask out loud. How could anyone prove such a thing? In an opinion dripping with skepticism, he observed that in the misty reaches of any family's past, tracing back far enough, hardly anyone's purity could survive scrutiny, that under such a test even the county's most respectable citizens stood in jeopardy, and he ordered the license issued. Arthur Sorrells got married. And here is the detail that reveals how fragile the system knew itself to be. The state declined to appeal. Plecker and Powell wanted to fight it, but according to historians of the case, the fear was that a higher court might strike the entire act down, so they let the loss stand quietly, went back to the legislature to try to patch the statute, and went on enforcing the law against people with fewer resources than a determined bride in Rockbridge County. That is worth underlining as a general rule of bureaucratic power. The system did not survive the challenge because it was strong. It survived because it chose its opponents, and because most of its targets could not afford a lawyer. One teenager had found the crack. It would take 4 more decades for anyone to drive a wedge into it. Moment 2 was slower and quieter, and it happened in the pews. While Richmond edited the official record, communities kept unofficial ones. The mission at Bear Mountain kept baptismal and school records naming Monacan families as what they were. Tribal families kept Bibles, letters, photographs, and their own rolls. Frank Speck's field notes and photographs from the 1910s and 20s, taken among the Rappahannock, the Chickahominy, the Pamunkey, and others, sat in university archives, a documentary record made by an outsider who had actually looked at the people Plecker classified by mail. None of it had legal force in Plecker's Virginia, and that was precisely the point of keeping it. They were building a rival archive and waiting for a day when someone with authority would finally be willing to read it. Moment 3 was exit. Families with the means simply took their vital events across the state line, registering births in Washington, D.C., Maryland, or Tennessee, delivering babies in out-of-state hospitals, or in some cases moving outright. Because a birth certificate filed beyond Plecker's reach was a birth certificate filed beyond Plecker's reach was a birth certificate he could not annotate. Plecker knew it was happening and fumed about it in his correspondence, badgering registrars in neighboring jurisdictions to adopt his suspicions, mostly without success. Weigh the cost of that for a moment. People uprooted their lives, left land, kin, and livelihoods, paid for travel and lodging they could barely afford, to win a single honest line on a single government form. That is how much one word on paper was worth. Moment 4 came on June 12, 1967, in the United States Supreme Court, and it began in a bedroom in Caroline County. Richard Loving, a white bricklayer, and Mildred Jeter, a woman of African American and, by her family's account, Rappahannock descent, grew up together in the small community of Central Point, went to Washington, D.C. in June of 1958 to marry legally and came home. 5 weeks later, in the middle of the night, the county sheriff and 2 deputies came through their unlocked door and arrested them in their bed, their marriage certificate hanging framed on the wall. Useless. Judge Leon Basile gave them a suspended sentence on the condition that they leave Virginia and not return together for 25 years, and when the case was reopened years later he defended himself with the words, "Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents, and but for the interference with his arrangement there would be no cause for such marriages." In 1963, Mildred Loving wrote a letter to Attorney General Robert Kennedy, who referred her to the American Civil Liberties Union, where 2 young lawyers, Bernard Cohen and Philip Hirschkopf, carried the case up the entire ladder. The Supreme Court's ruling was unanimous, 9-0. Chief Justice Earl Warren writing that marriage is one of the basic civil rights of man, and with that, the enforcement heart of the 1924 Act was gone. Plecker did not live to see it. He had retired in 1946 after 34 years as registrar, and died in Richmond in August of 1947, at age 86, struck by a car while crossing a street. The machine outlived the man by 20 years. The paper outlived them both, because Moment 5, the final promised item, shows what erasure costs even after the erasers are gone. When Virginia's tribes petitioned the federal government for recognition, the standard administrative process at the Bureau of Indian Affairs demanded documentary proof against 7 criteria, among them continuous existence as a distinct community and continuous political authority, traced decade by decade through paper. And what did the archives hold? Decades of certificates saying colored, files whose Indian entries had been struck, annotated, and overwritten by the very state now being asked for evidence. The federal process, in other words, asked the tribes to disprove Plecker using archives Plecker had spent 34 years salting. The tribes call it paper genocide, and the term is precise because it was not people who had been removed. It was the record of them. The Pamunkey, who held colonial-era treaty land and an unbroken reservation, won federal acknowledgement through the administrative process in 2015 after decades of effort. For 6 other tribes, the documentary wall was so high that it took an act of Congress to go around it. The Thomasina E. Jordan Indian Tribes of Virginia Federal Recognition Act, named for a longtime chair of the Virginia Council on Indians, signed into law on January 29, 2018, recognizing the Chickahominy, the Eastern Chickahominy, the Upper Mattapony, the Rappahannock, the Nansemond, and the Monacan, and understand what recognition is in material terms because it is not a ceremony. It is standing to hold land in trust, eligibility for federal health, housing, and education programs, and the legal right under federal law to reclaim ancestral remains from museum drawers. 2018, 94 years after the act, 71 years after Plecker's death, the ink he put on paper in the 1920s was still deciding, in a legal sense, who existed. There is one more document, and this episode saved it for last because it answers the loop opened in the first minute, the question of which government Plecker believed his system had outperformed. In January of 1943, he sent out one of his surname circulars, the mailing this episode promised you, addressed to local registrars, clerks of court, physicians, nurses, and school superintendents across Virginia, listing, county by county, the specific family names he wanted flagged and watched. Amherst County names, Rockbridge County names, Wright families identified by name in an official state mailing and marked as suspects for the crime of their own surnames. In that circular, he described those families in his own words as like rats when you are not watching, sneaking their birth certificates to unsuspecting midwives. And in correspondence from that same period, preserved among his papers and quoted by the historians who have studied him, Plecker boasted about the reach of his registry by way of a comparison. He wrote that Hitler's genealogical study of the Jews was, in his estimation, not more complete than the racial files of Virginia. 1943, the middle of the war with Virginians dying overseas fighting the regime he named. An American state official measuring his own filing system against Berlin's and finding his own superior. One caveat belongs here, and it cuts deeper than the quote. Plecker was not a dictator, and Virginia was not a police state. He was a salaried clerk in a democracy, holding an office almost nobody watched, answerable in theory to a health commissioner and a legislature that, for 34 years, found no reason to look closely at what the quiet man in vital statistics was mailing. And that is the actual lesson. It did not take troops to reclassify a people. It took a bureau, a mailing list, and 34 years of nobody asking who controlled the file. So come back at the end to the object this all runs through, because you own one. Somewhere in a courthouse or a records office, there is a certificate with your name on it, filled out when you were days old by people you will never meet, and everything downstream of you, your passport, your license, your marriage, your estate, flows from what that paper says. When Social Security arrived in 1935, millions of Americans discovered overnight that their entire claim on a pension ran through a piece of paper some clerk had or had not filled out decades earlier, and courts spent years processing delayed birth certificates for people the record had simply missed. For most of us, most of the time, the ledger is honest, and so we forget the thing this story exists to remember, that a record is not a fact. A record is a claim written by whoever holds the pen. And the history of Virginia between 1924 and 1967 is a controlled experiment in what happens when the pen answers to no one. The families on Bear Mountain never stopped knowing who they were. It took the United States government until January of 2018 to catch up with them. The paper was wrong for 94 years. The people were never wrong for a day. If this channel's way of pulling the hidden wiring out of ordinary institutions is worth your time, subscribing costs you nothing and tells us to keep digging. And the like genuinely helps this episode reach the next person who has never once asked who filled out their first piece of paper. I will see you in the next one.